Hello folks, Don Rolfe here on this 23rd of July 2019, and I am here to talk to you about how to protect assets from creditors, predators, and exes. By the way, if you have any questions about this or any other estate planning topic, probate topic, or if you just want to chat, feel free to reach out to me at myestateplanmeeting.com, and I'll be happy to answer those questions either in person or on the phone, and let you know about estate plan options that are available to you. But how do we protect our assets from creditors, predators, and exes? So I'm just going to lump this all into one, anybody that's out there trying to get money from you, right? How do you protect your assets from them, especially if they might be, of no fault of your own? The first thing that you can do is be proactive. Have a plan in place, obviously. So if you're already at the point where you have someone has sued you, or there's something that's happened where there's a suit that's coming, or you're already married, then getting protection from those sorts of things is really a lost cause, because your assets are going to be available for execution on a judgment that comes out or something like that. Or, your divorce, you're going to have either your spouse or you are going to, you're going to be equaling out the money. Really what you need to have done is had a plan in place to begin with. The number one thing you can do is have insurance, because a lot of times what will happen is people will have creditors coming after them, or judgments coming after them for things that could have been covered by insurance. And if you don't have the right type of insurance, especially if you're a business owner or a person in a professional practice of some sort, you really need to make sure that you have the right kind of insurance and the right coverage amounts to protect your assets underlying. If you're a business owner, you need to make sure you have the right types of entities set up to make sure that you have your limited liability to the greatest extent allowable. If you're going to be thinking about getting married and one of you is coming in with a lot more wealth than the other, it never seems to bode well to say, hey, we need to get a prenup put together. But in all reality, that is the best case scenario, is to have an agreement up front that if things are going to sour, things go sideways, whatever it is, of no fault of your own or fault of someone's, it doesn't matter, that there is a predetermination of how assets are going to be divvied up when that happens, or if it happens. So also along those lines, if you do not have any creditor problems right now, if you do not have anything going on, you can actually set up different types of trusts called asset protection trusts under the laws of several different states. Right now, Nevada comes to mind, that actually allow you to place your money under the control of another trustee where you're still the beneficiary, but those assets would be outside of your estate and protected. Now, there's several steps that you have to go through to make that happen. There's a certain amount of time that has to pass after you've transferred those assets before that protection takes over. So it's difficult, but it is absolutely possible. If that's something that you're really, really, really worried about, it's something that can be set up for you. Now, the easier way to protect assets is to have someone else, a third party, set up that protection for you. And the way that happens generally is through inheriting assets into a trust, or someone giving you assets into a trust. It's really hard to do it with your own assets. I guess technically you could give them away to someone and they could give them back, but really what that kind of thing boils down to is that a fraudulent transfer? Was it really for value? And fraudulent transfers are a big deal, because not only can those be unwound, and the effort that you put in to make it happen, to try to protect those assets, can be undone, but also there can be penalties involved for trying to perpetrate fraud on creditors, basically. But for you, if you have children and beneficiaries that you're going to be passing assets on to, it is very simple to make sure that they get the types of asset protection that you wish that you had right now. And you can do that by leaving their inheritances to them, or their bequests that you give them, in a trust. And I've done other videos about how that works, but basically the way that it works is that money is separate, held in a separate entity, their trust. that will protect it and shield it from their creditors. If they file for bankruptcy, if they get sued for an automobile accident, all of those sorts of things, there's mechanisms inside of those trusts that will protect those assets against those types of claims. Even claims for ex-spouses, because generally inheritances, when you receive them, remain your sole and separate property, even in most community property states, which Oregon is not one, but it remains your sole and separate property. And that can be defeated very easily by you inherit $100,000 and you put it in your joint checking account with your spouse. That's said to have been transmuted into joint property. However, if it's held separately in a trust, there really isn't that option for commingling the funds and your spouse claiming that it was a gift if at some point down the line, a gift to them if at some point down the line separation and divorce is what's going to occur. So by leaving your assets to your beneficiaries in a trust, it isolates them, it protects them, insulates them for creditors, and your beneficiary or the person that you're leaving the bequest to in trust, they could actually be their own trustee, and when a problem arises, they could step down as trustee, appoint an independent, non-subordinate, independent person to be trustee of that trust, and then when the creditors tried to collect, that new trustee could, if they so chose, pay out to the creditor, but they probably would not because they have no obligation to do so, and they could tell that creditor basically to go pound sand. Now, this doesn't mean that it's real simple. It's just, it's not something that you want to try to do on your own with on a legal pad or something, or sit down at the word processor and type it out. I mean, there's certain formalities that have to be followed. But in the realm of estate planning, protecting the inheritances that you leave behind is a relatively simple process, and like I said, doing it in a trust is the most beneficial way to do it. And I set up these trusts for all kinds of clients. By the way, if you have any questions about this, do feel free to reach out to me at myestateplanmeeting.com, and we can chat on the phone or in person for absolutely nothing out of your pocket, and I can answer those questions for you and tell you your options for estate planning and see if any of this would be good for you. And if it's a good fit and you'd like to work with me, we can do that. Or if it's something you'd like to do but you detest me, you don't like me, I can refer you out to another estate planning attorney. I'm happy to do so because I only want to work with people that want to work with me. So again, it is very possible to protect your own assets. There's just a lot more hoops to jump through, and there is a lot more cost associated with it, but protecting the assets that you leave behind for others is a relatively simple procedure, and it's well worth it. Like I was saying, I set these trusts up for all different types of people, whether they're leaving, $50,000 to a child who makes $500,000 a year, or they're leaving $1 million to a child who has yet to even start their own career. Both of those scenarios, it's good to protect the money. In the first scenario, where you're leaving a little bit to someone who has a lot, it's also a good way to segregate that money out so that when they spend it, they remember who it came from and what it's going towards. So, when your son inherits the $50,000, even though it's not going to make a blip on his radar, his financial radar, when he writes the check to send the kids and his wife and him to Hawaii for a week, out of that account, they know that, hey, mom and dad sent us on this vacation with the inheritance they left. Anyway, I'm Don Rolfe, owner and founder of Northwest Legal Planning. I am happy to come on here and chat about these things. If you like this, please indicate so below. Hit the like button or share. I would really appreciate it. If you think you know someone that would benefit from this information, share it with them. Put it out there. If you have questions that you'd like me to answer when I'm jumping on here to do these little live videos, put it down in the comments or send me a message. I would love to answer questions from you guys. That is why I do this, is to get information out. And I do answer questions that I get. I come up with topics of my own if I'm not getting material from you guys. But it would really, it's really simple for me to hop on here and answer a question, because if you've got the question, somebody else surely has the question, and the more people that are informed, the better. I want to give out good information. Of course, this is not legal advice. It's just general in nature, but please, feel free to reach out to me, ask me the questions that you may have, and I'll be happy to answer them. Again, please like, share, and if you like listening to my voice, you can also pick this video up in audio format over on iTunes and pretty much anywhere else that podcasts are available. On Estate Planning Weekly is the name of the show. All right, until next time, take care. Bye.